What is the law? And who is above it?
A democracy cannot thrive where power remains unchecked and justice is reserved for a select few. John Lewis.
Wonderland. For most of my life, I have enjoyed fictional courtroom drama. Now that I have evolved past fiction into objective reality, I must say, the popular fiction gets many things wrong and fundamentally fails to understand the issues, stakes, and risks to society. Quell surprise. It should come as no surprise that the media gets a lot wrong, but when it comes to law and its effect on society, it would be nice if the media could set aside profit once in a while and actually do some decent investigation of objective reality. Compared to my domain, computer science and software engineering, the domains of law and justice are really more like Lord of the Flies than I ever would have imagined. It's interesting these days how relevant those books we read in school have become. Another story, The Lottery, is also very relevant in my current experience, where it is astonishing how much in law and justice is rationalized because that's the way we have always done it. See also Stare Decisis. The law and justice are more akin to politics and religion, where the law is written by politicians and the justice system operates more like the clergy. For this scientist-engineer, I really feel like I have fallen down the rabbit hole into Wonderland. The best way to describe what I have found is a reality distortion field, a term first used by Bud Tribble, used to describe Steve Jobs and his effect on people working at Apple on the Macintosh project. What is law? Laws are rules that can be enforced. There are two kinds of laws. The laws of nature are enforced where humans have no control over such laws. The best we can do is understand them and reach for our goals and objectives while working within them. No one is above these laws. The laws of people that might be enforced where humans have complete control over such laws and can obey them, ignore them, or manipulate them, can use them to protect or exploit others. Despite anything the Supreme Court of Canada says, many people are above these laws. Nature does not defend us nor exploit us. Nature is indifferent to us. But people choose to protect or exploit others, and the laws of people can be wielded as either a shield or a sword. These statements are objectively true, grounded in objective reality. For the most part, discussions about the laws of nature address the domain of objective reality, what is real, relying on the disciplines, doctrines, and methodologies of philosophy, logic, mathematics, physics, chemistry, biology, astronomy, etc., that are investigated via the scientific method. However, when we try to discuss the laws of people, we tend to diverge widely from objective reality into subjective reality, where concepts of true and false differ from one subjective perspective to the next, and concepts of right and wrong are even more nebulous and ethereal. Indeed, when it comes to ethics and morals, nature has nothing to do with such human fantasies. Yet we are told our laws are based on ethics and morals, and lawyers are told to be ethical, but operationally they are culturally and systemically motivated to be unethical and even immoral. Lawyers profit from other people's disputes, and in Canada, the architecture of the justice system serves the Crown first and the people second, similar to neoliberal trickle-down economics. Syllogism, logic, axioms, and corollaries.
The life of the law has not been logic, it has been experience. The felt necessities of the time, the prevalent moral and political theories, intuitions of public policy, avowed or unconscious, even the prejudices which judges share with their fellow men, have had a good deal more to do than the syllogism in determining the rules by which men should be governed. The law embodies the story of a nation's development through many centuries, and it cannot be dealt with as if it contained only the axioms and corollaries of a book of mathematics. The substance of the law at any given time pretty nearly corresponds, so far as it goes, with what is then understood to be convenient, but its form and machinery and the degree to which it is able to work out desired results depend very much upon its past. Oliver Wendell Holmes, Jr., The Common Law.
But what does that mean?
Lawyers from Justice Holmes's day until today rally around the banner of his most famous quote, "The life of the law has not been logic, it has been experience." Supposedly, this phrase reminds judges and other lawmakers never to let the law lose touch with the needs of ordinary people. In historical context, however, the life of the law says nothing about how judges should decide cases. Rather, it expresses Holmes's view about how common law judges actually decide cases. More specifically, Holmes's experience refers to judges' mostly subconscious intuition, while logic refers to a vain attempt to systematize intuitively developed law. Proper understanding of Holmes's famous quote, revealed through this article's historical analysis, helps to avoid an unfortunately common analytical distortion, and one which tends to stultify the law, what Holmes called the danger of inventing reasons offhand for whatever we find established in the law. Brian Hawkins, The Life of the Law, What Holmes Meant, SSRN Electronic Journal, May 2012.
We will explore these statements later, but for now, trust that they are foundational to this book in answering the question, in Canada, who is above the law and who is below? Weapons of war. Canada's criminal code is a fundamental declaration of war on the people.
289. The criminal law is one of the most aggressive weapons the state has to enforce its dictates. This weapon must be wielded with great care. The courts must intervene when an enactment violates constitutional guarantees. R.V. Malmo-Levine, R.V. Kine, 2003, 3 SCR 571, 2003 SCC 74.
In R.V. Malmo-Levine, R.V. Kane, the court reminded Parliament that criminal code provisions are among the most aggressive weapons the state has, and must therefore be narrowly crafted and fairly applied. When a law is vague, overbroad, discriminatorily enforced, or paired with disproportionate penalties, it can become a political cudgel rather than a measured tool for public safety. The court's statement signals that Charter Review, S7, Life, Liberty, Security of the Person, and S12, Cruel and Unusual Punishment, is society's chief protection against that risk. Malmo-Levine's caution is not rhetorical hyperbole. Canada's recent history shows how readily criminal statutes, bail regimes, and prosecutorial discretion can become instruments to suppress dissent or perpetuate systemic inequities. Courts remain a critical line of defense, but legislative design, transparent data, and meaningful oversight are equally necessary to ensure the most aggressive weapon is wielded with the restraint demanded by a liberal democracy. Court allegiance, crown fealty versus public trust. Across the Commonwealth, the sovereign is styled fons juris, the symbolic fountain of law. Yet Canada's constitutional architecture insists that the wellspring of legitimacy ultimately flows not from the Crown's prerogative, but from the people's trust in an impartial, transparent judiciary. When courts adjudicate, they are called to stand above political winds, partisan expediency, and even the executive branch that initiates most criminal proceedings. Their first fidelity is to the rule of law itself, the idea that no office holder, no matter how exalted, may bend legal principle to private ends. In this light, allegations that a senior official has breached the public trust are not affront to governmental dignity. They are tests of the justice system's moral circuitry. A court that reflexively shields the Crown risks severing the oxygen supply, public confidence that keeps its own authority alive. Unfortunately, Canada's legal history is punctuated by episodes in which deference to executive power eclipsed the duty of fearless scrutiny. From politically sensitive prosecutions quietly stayed under S-579 to mandatory minimum regimes later struck down as cruel and overbroad, patterns emerge of a culture that too often treats rules as pliable suggestions for the powerful and iron shackles for everyone else. Above the law, the Crown's culture of ignoring rules traces these fault lines, showing how structural asymmetries, institutional self-interest, and opaque decision-making erode the very legitimacy the Crown claims to protect. It argues that reclaiming public trust requires re-engineering the justice system so that allegiance to principle rather than fealty to power guides every prosecutorial choice and judicial ruling. Testing moral circuitry. Nothing in these pages rests on armchair speculation. The tests of the justice system's moral circuitry invoked in the opening essay are literal stress tests I ran against British Columbia's legal machinery. Each filing, from a Section 140 complaint to a Police Act service or policy complaint, to a private prosecution for breach of trust, to a BC Supreme Court petition for judicial review, became a diagnostic probe revealing where the current flows and where the fuses blow when the accused happens to wear a badge, sit on a board with the title of King's Counsel, or be a Minister of Justice. Between August 2023 and August 2025, I initiated 4 escalating tests. 1. An allegation of public mischief to the Vancouver Police Department, VPD, Section 140 of the Criminal Code for falsely reporting a crime. 2. A comprehensive 108-page service or policy complaint to the Vancouver Police Board, VPB, outlining problems and offering remedies. 3. A Section 504 private information alleging the chair of the VPB SPCRC violated Section 122 of the Criminal Code, breach of trust by a public officer. 4. A petition for review under BC's Judicial Review Procedures Act, JRPA, requesting certiorari and mandamus, alleging an improper Crown stay of my private information via Section 579 of the Criminal Code. In these cases, I found conflict of interest, pseudo-oversight, and a culture of impunity. However, I also found this impunity is grounded in a culture of desperation. People utterly desperate to be in control, to cling to their power as if nothing in this world is more important than power and control. These were not preconceived notions, these were astonishing discoveries. 1. When the police department receives a complaint of a false allegation of a crime after the accused has been acquitted, this becomes a conflict of interest for the police, because any investigation of the complaint could reveal bad faith or worse, improper investigation and recommendations of the falsely reported crime. Refusing to investigate a Section 140 crime can also be viewed as aiding and abetting that crime and obstruction of justice. 2. When the police board, supposedly an independent oversight agency, receives a comprehensive complaint of police services and policies, any investigation could reveal defects in the oversight role, also bad faith actions or worse. When the police are allowed to be self-policing, the systemic invitation to conflict of interest should be obvious. 3. When the Crown stays a private prosecution, after being forewarned several times of conflict of interest, requests for an independent special prosecutor, and reasons for an anticipated stay, but all are ignored, that is clearly a conflict of interest. Also, staying a private prosecution of one of your colleagues can also be viewed as aiding and abetting a crime and obstruction of justice. 4. When the Crown uses gaslighting to intimidate a petitioner, directing him to withdraw his petition with threats of court costs instead of directly filing application to strike, that is subversive behavior, compounding the previous conflicts of interest. It's not that the Crown should not be able to defend their actions, but they should not employ dirty tricks in doing so. This was never intended to be a test, an experiment, nor a crusade, but the results of each test were analyzed by a scientist as if they were experiments, leading to a crusade of the Socratic method. If you offend a curious man, he responds not with retaliation, but with questions. Questions that become conjecture, and hypothesis. Hypothesis that requires validation and verification that leads to astonishment. Philosophically and spiritually, I can only imagine how Copernicus and Galileo must have felt when the Church objected to their questions, or how Socrates felt when his peers became desperate and fearful of his observations. Such patterns are not historical curiosities. The wrongful conviction of Ivan Henry, 26 years lost and an $8 million settlement, stands as a monument to what happens when conflict of interest meets prosecutorial obstinacy. My encounters suggest that the same culture still prevails.
guarded by legal doctrines that grant sweeping discretion and airy immunity to those inside the circle. In the book, Prosecutorial Misconduct, 2nd edition, Robert Frater meticulously lays out moral and ethical crimes of Crown Counsel, while the court maintains that Crown Counsel is above the law with respect to prosecutorial misconduct.
Nepotism is the lowest and least imaginative form of corruption. Daniel Alarcon.
Above the law argues that this culture of deference is incompatible with a functioning democracy. By moving from philosophical first principles to the gritty particulars of my own cases, the book invites readers to see systemic flaws not as rare aberrations, but as predictable outcomes of a design that privileges institutional self-preservation over public trust. Reform is not philanthropic altruism, it is democratic maintenance. As civil rights icon John Lewis cautioned, a democracy cannot thrive where power remains unchecked and justice is reserved for a select few. The aim of this book is to explore this problem with our justice system in more detail, as well as other problems, with the hope of persuading the reader to have a sense that we must reform the justice system if we are to have a more robust democracy, as John Lewis notes. Hopefully, I have addressed the question, what is the law? To address, and who is above it? Spoiler alert, a conclusion of this book is that, aspirationally, according to Canada's Constitution and the Supreme Court of Canada, no one is above the law. Operationally, the Crown is above the law, and there is little the Supreme Court will say or do to change this. Legislators generally evolve the law to take power from the people and give it to themselves and the Crown. The court's fealty, therefore, is to the Crown first, the people second. Given the courts have declared time and time again, they assume the Crown is reasonable by default, defer to Crown Counsel, not the people, and have granted Crown Counsel almost complete immunity via common law, it is objectively true the court's fealty is to the Crown. Politically, while the people may vote for who forms the government, after an election, the power of the people stops there, mostly. Nothing in law guarantees that elections are fair. In Canada, the Crown does not desire democracy, it demands obedience. If Canadians want justice, they must demand it, because the Crown will always look after its own institutional self-interests first. Fundamentally, the culture of the justice system is that to hold the people to the law, the Crown must be above the law.